Yes, so I'm Peter. It's very nice to meet you all. I am a UK and European patent attorney. I work for a firm called Williams and Powell, and we're based in London in the UK, but thankfully the European patent system is not connected to the EU particularly, so we still have the pleasure of working across Europe actually and have many clients in different countries across Europe. And we've also had the pleasure of working together with Enterprise Estonia for some time, and also with some clients, some here today, I'm pleased to see, in Estonia. So it's great to be here. We contacted Enterprise Estonia. I was visiting and we suggested maybe doing a seminar, and if we asked if there were any topics that might be of interest for us to discuss. And one that came up was this idea of how to read patents. And so we talk a lot about, we might think a lot about patents and how we can protect our inventions. But one topic that's very difficult to get hold of sometimes is how to actually read a patent document. So we were delighted that this was suggested as a topic. I think it's a very interesting thing to look at. And hopefully today we can give some helpful tips that will help you as businesses or whatever you're working in, when you come across a patent document, how to actually understand what's in it, how to extract the relevant information from it. So that's what we want to do today. It's a subject that's quite close to my own heart. Before working in the patent profession, I was an academic researcher. So I spent many years as a postgraduate and then a postdoctoral researcher at University College London. And as part of that, as any academic researcher does, I'd have to do a lot of literature review and read a lot about the technology that existed around my area. Occasionally, I'd come across a patent document, and to be honest, I never really knew where to start with it. There was so much information. It was presented in a way that sort of looked a bit like an academic paper that I was used to, but actually was a bit different. And trying to understand what it taught me was quite difficult. And so I remember back in those days really struggling to read patent documents, and the truth is that probably more often than not, I just ignored them because it was quite difficult to get the information I wanted. So it's something that I'm very familiar with, this issue of how to read patents if it's something we're not familiar with. So that's our aim today. Just to give you an overview of what we'll talk about, we're going to divide today into two sections. Sim, when we were organising this session, suggested that we have quite a practical field to the seminar, and I think that's a really good idea because it will give us an opportunity to actually look at some documents and put some of the theory into practice. So we're going to spend a bit of time talking about the theory, but we will then maybe have a short break and look at some exercises. So that's where these documents will come in later, and hopefully that will just help put some of the I'm going to talk for a while, but it might be easier actually to understand some of it when we start to look at the examples. But we'll start with looking at why patents matter and why we want to read them, why we might want to read them. We're going to cover some ideas, the topic of patentability. What is patentable? What can we protect? And even though that's not the focus of the talk today, I think it's useful because it frames how patent documents are put together and helps us to understand why they're written, how they are. And then we'll get into some of the details. So we'll look at the structure of patent documents, how they're set out. We're also going to look at looking at bibliographic information, and I'll explain what I mean by that later. And it might sound boring, but actually there's some useful, interesting information that we can get there. And then we'll look a little bit more at the technical detail, and in particular look at claims and description of a patent specification to understand what these are actually trying to do and how they interact. And that will help us hopefully understand how we can start to tackle reading them. And then, as I said, we'll take some practical examples at the end. But as we go, if you have any questions, please feel free to ask, and it'll be good for it to be a nice interactive session. So we'll start with just a brief recap. Why do patents matter? Why are they important? Ultimately, they protect innovation. They keep competitors out of the market space. That's what they're designed to do. It will enable the owner to stop other people using that same invention that is protected by the patent. But there are also other things, other ways that patents can be useful and other reasons that they might matter. They can be useful for raising licensing revenue as well, so introducing additional revenue streams. For example, if you have a patent covering a number of countries, or you have several patents covering different countries, you might not be operating in all of those countries, but the patent would allow you to license the technology to someone who is. And so there's potential additional revenue streams there. And another key area that we see with a lot of clients is enabling and enticing investment. Patents are something that investors will like to see if they're going to invest in a company. It shows not only that the technology that the company is using is protected, but it also shows that it is developing technology and is also serious about protecting it. So from an investment point of view, and from raising investment funds, it can be a very useful thing to have. And this is just something we always like to say as we talk about patents, is that any IP, intellectual property strategy, patents being one tool in your IP toolkit, any strategy should review the cost of that IP against the benefit. And particularly with patents, you can potentially protect a lot of innovation, but you've always got to think about where is the commercial value in protecting it. Am I going to get a return on my investments if I spend money getting a patent in place for this technology? And so that's why patents matter. Perhaps not the focus of today. What we're looking at today more is why might we want to read a patent? Now, hopefully, I think because you're all here, that suggests that I don't need to convince you on this point. You've all got some interest in understanding how to read a patent. But I think a lot of us might come in from different angles. We might have different interests. And so taking an overview of what sort of information we can get from a patent and why we might want to read it could open up different thought processes. So I'll try not to stand in front of the screen. That's not very helpful. So from a first perspective, we might want to read a patent to establish freedom to operate. And so what I mean here is, if we see a competitor's patent that belongs to someone else, does it cause me a problem? Does it prevent me from using a technology that either I already have or perhaps that I'm wanting to develop? So it might be a concern over a specific patent and a specific technology that you have, and you want to know whether or not you infringe. It also might be that you're looking into new areas and you're looking to develop in new places, and actually you want to see if there are any barriers to entering into that market. Are there patents, or you might have a patent that you wonder, does this create a problem for me stretching into this new area? But also from the point of view of technology intelligence, it can be very useful to understand how to read patents. And so by this I mean understanding actually what the technology is, what has been done by the patent owner. Patents protect something, and generally that's framed to be quite broad, but that's not necessarily what's actually been done. And if we want to understand the research, if we want to understand the work that's gone behind the patent application, we need to know how to extract it. So from a technology intelligence point of view, it can be very useful. And this goes back to my example of being an academic researcher. Actually, a lot of my interest in patents might have been understanding what work had been done. It's the way we can see what's being carried out in industry compared to academia, where we're used to seeing a lot of publications and researchers will publish the work that they've done. We don't see so much of that in industry unless we start to dive into the patent documents. So there can be a lot of useful information there for us in understanding our own technology. It can help us to identify market opportunities and also to develop our own research and development strategy. So, for example, we can see areas that might be congested or see areas that might be covered and that could help us focus our own research efforts into fruitful areas, places that we might be able to create some ground that we're not blocked from entering because of difficult patents. So in reviewing our own research and development strategy, there can be benefit to actually understanding what is protected in other patents and also what's been done. So the technology intelligence aspect might give us ideas of where we can focus our own research efforts. But then also for protecting our own innovations, it's good to know and to understand what patent documents actually disclose. And some of you might have been through the patent application process before, so you might be familiar with this, but typically if you're trying to protect your own invention through a patent application, what will happen is the patent office will carry out a search. They'll find a lot of what we call prior art, and that's existing documents and often patent documents that relate to a similar technology. And what you have to establish is that your invention is patentable over those prior documents. And we'll talk a bit more about that later. But understanding exactly what those documents do and do not teach and where your research fits in can help you understand where you can protect your own innovations. It will help you draft robust patent applications as well, because you can frame it within the context of what's been done before. But also in this process, you might likely be working with a patent attorney, someone like me, who will take all the information. You'll have a lot of discussions about what the invention is, and then the patent attorney will draft that application and then send it back to you. And it's really helpful for us if you actually understand what that document is saying. Why have we written it the way we've written it? Why have we used the words and the language that we've chosen? Because it might be a bit confusing. So the more you understand about how to read a patent document, the more fruitful that process between you and your attorney will be, and that will help ensure that your application is as robust and strong as possible when it gets filed. So we'll just take a step back and just remind ourselves what a patent is before we go into some of the detail about how to read it. A patent is protection for an invention. It gives the owner the right to stop other people from using that invention, and so it gives this monopoly. An important distinction to make there is a patent that you have doesn't necessarily give you the right to use that invention. It gives you the right to stop other people from using that invention. And so it's just important to keep that in mind whenever you're thinking about patents, because a patent itself that you own could stop other people, but it's still possible that other patents exist, pre-existing patents, that could still be problematic. So your own patent does not necessarily give you the right to use that invention, but that's what a patent is. It's setting out a monopoly for this particular invention. And I say here it's the claimed invention. So it's what do we actually claim in this patent application, and then eventually granted patent. That is what is protected. And that monopoly is granted for a particular territory. And we'll come on to this again later. But it's important to remember that patents typically cover a country, perhaps in some cases a group of countries, but they are not worldwide. If you want to protect something, it needs to be protected in every country that you want to protect it in. This monopoly comes as a bargain, and that bargain is a full disclosure of how to work the invention. And this is the trade that you make essentially with the state of whichever country it is that you're obtaining a patent in. They will give you a monopoly on the invention, but you have to make a full disclosure of how to work it. The idea behind this is that it's encouraging innovation. It's putting information into the public domain, and yes, you can protect that for a limited period of time, but it helps drive innovation because we can see how things are done rather than it just being kept secret. And this will become important later when we think about how a patent specification is written. So what's patentable? Essentially, a patent can protect anything from how something works, what it does, how it does it, what things are made from potentially, and how they are made. And so we end up with lots of different types of patent claim. So we might have a patent claim to products, apparatus or devices, systems, so sort of more physical things that we might claim, but also processes or uses of particular, in the chemistry field, for example, uses of particular compound in a specific application can potentially be protected. So there are lots of types of patent claim we might come across because there's lots of different things we can protect. And we're just going to recap on patentability, and this might be something that you've come across before, and we've spoken before in different seminars. But essentially, anything that is novel and inventive and not excluded can be patented. So just to recap what these different things mean. First, novelty is essentially meaning that the invention has to be new. It can't be something that's been done before by someone else. What it means is that it's not the same as the prior art. And I mentioned this before, but the prior art is something that existed before you filed the patent application. So often in the application process, you're looking at other patent documents, but anything that's in the public domain is prior art. So anything that's been put in a journal article, on a blog, presented at a conference, could potentially be prior art. Even products that are on the market could be prior art. So to protect the invention, it needs to be new over everything that's gone before. In some fields as well, a new method of manufacturing something could be patentable, it could be new. So, for example, we might have a product that is a product that's been on the market for a long time, but you've identified a new way of making it that's a little bit better than what's gone before. That could be potentially protected, that method. And also, as I've mentioned, potentially a new use of a known product could be patented if it's something that's not been done before. Novelty is quite a narrow concept. It's either been done or it's not. And there's not sort of a degree of novelty. It's not a question of, is my invention novel enough? That will come on to later. It's either been done or it's not. But then the second step, the second hurdle is the hurdle of inventive step, which might be a concept that you've come across before. And this is the slightly higher barrier that we need to get over to establish that something is novel. We need to show that it's not an obvious modification of the prior art to what we call the skilled person. Now, this can be, as researchers, a difficult idea to get our head around, because by nature, if you're looking at an invention or perhaps some technology that you've developed, but by nature, you're quite creative, you're quite inventive in the work that you're doing. And so you might look at developments that you've made and not think much of it, not really see the particular benefit. But the skilled person isn't someone with that level of creativity. The skilled person is just someone who knows the field, knows the technology, is skilled in putting that sort of technology into effect. But they're not very creative. They're not very good at thinking outside of the box. They're not going to necessarily automatically piece together different pieces of information. So it's someone who knows about the field, but not someone who's inventive in any way. And so that's important to remember, because we can miss sometimes our own innovations because we think they might be, we don't think that they're particularly clever. Inventive step often means that it solves a technical problem, and the way that in a lot of patent offices the examination is framed is what's the problem that exists in the prior art, and how have I overcome that problem? So you might, for example, have come across a new, let's say you're working in a chemical field and you've come across a new reaction mechanism that gives a faster reaction or improved yield. It's the problem there is how, you know, our process isn't efficient. How can we improve that efficiency? And our solution is the new method that we've come across. So that's a useful way of framing this idea of inventive step. It's examined slightly differently in different countries, but generally those are the same questions that are being asked by patent examiners across the world. And then just to briefly mention this idea of excluded matter. I won't talk about it too much. It's the subject of a seminar in itself. But there are certain things that are excluded from patentability. In Europe, things like business methods, methods of medical treatment and diagnosis are excluded from patentability. That's not to mean you can't protect a product that you might use in a medical treatment or a compound, a drug that can be protected. And obviously the pharmaceutical industry is a huge player in the patent world. But the actual method of medical treatment itself can't be protected. And the idea behind this is that as the patent law was put together, it's not right that a doctor in a situation wouldn't be able to treat a patient because they would be infringing someone's patent. But that doesn't mean that the tools that they might use, the kits or the drugs that they might use, they can still be patented. And then also a big area of exclusion is the area of computer programs. I won't go into this in too much detail. I don't know how many people here might work in this world, in the world of software, but it can be a misconception that software can't be patented. It can be, it's just the way that that's framed. It depends what the software is doing. It depends how it's interacting with other systems, and what the technical effect it's producing is. So computer programs can be protected, and if you've got something that you've developed that you think has made an improvement, it's always worth talking to a patent attorney to consider whether that could be protected. So the reason I just go over those concepts, firstly, so we're all sort of familiar with the ideas that we're talking about, but also a patent specification is written to tell this story. It's written to tell the story of what is new, why is it clever or advantageous, so what problems has it overcome, where's the inventive step, and how can we actually put this into effect. So understanding that helps us understand what patent specification is all about. Let's take some water. If there are any questions, please do stop me. I've been talking already for a while.
One question, maybe it's a weird one, but you said like about inventive part.
Yeah.
That it's not obvious modification to a skilled person. Like, have you ever heard like a stories actually in the past that like something was novel and not excluded, but it was stopped being patented because it was not innovative enough?
Quite often, yes. And as I said, it's the harder barrier that we have to overcome as patent attorneys when we're discussing with the patent office. A lot of our job is to convince the examiner that this invention is inventive. So it's quite easy often to establish that something is new and it's not been done before. But then showing that it provides some sort of advantage in a way that would not be obvious is often the challenge. And I would say it comes up in the majority of cases. We'll actually talk through maybe some examples later, which might help put that into mind. But it is something that we always, at the first stage of identifying an invention, as patent attorneys, we need to understand from you where the advantages are, what the benefits are, what problems that have been overcome are, and whether it would be obvious to do what we're suggesting to do. So to take my example of the use of reagents, different reagents in a chemical process, it might be that there's a known chemical process out there and you've swapped in one reagent for another, and you found that that's produced a better yield. If it's quite well known within the field that you can use different reagents and actually that a particular class of reagents might have that effect, that's something that is likely to be considered by a patent examiner to be obvious. It'd be obvious to carry out that routine experimentation and play with the method a little bit to try and improve it in a way that is understood and well known. However, if that's having some sort of unexpected effect that you couldn't necessarily predict, then that's where there might be an invention. So it will differ depending on what kind of technology we're working with. but yeah, it does come up quite often. So
I have another question.
yes.
Like about the prior art, but like the other way around. If we're writing the research papers, me as a researcher,
Yeah.
I do not do the prior art research in patents, but if, for example, suddenly I will write something in the paper that has been patented, but there is no research paper to it, is it like my new paper infringing then some patents, or like?
Good question. So typically, a patent won't be infringed by experimental use of the invention. So testing the invention, carrying out experiments for non-commercial purposes typically won't infringe. So if you publish a paper that might use that technology, it's not likely that there'll be any infringement. If there were then a commercial application to it, you might have to be more concerned about whether your research falls within the scope of the patent. Yeah, does that answer your question?
Yeah.
Okay, so we'll have a little bit more of a look now, deeper dive into patent documents themselves, so we can understand what they are saying and how they're put together. First point I actually want to make on this, I'm referring to patent documents, and the reason for this is that actually we might see two types of publication. Patent applications are published before they're granted, and then once the patent is granted, it's published again. So again, anyone who's been through this process before might be familiar, but this is kind of what a typical patent application process looks like. We'll start with the drafting stage. So that's where you might be working with your patent attorney to identify exactly what the invention is and put together the patent specification, all of the technical information relating to the invention. Once that's ready, we proceed to file it at a patent office in the country that we want to protect it in. And then we go into this process of search and examination, which is a back and forth between the applicant and the patent office. Normally, a patent attorney is the one representing the applicant in that scenario. The search phase is where the patent office looks for documents that are similar, anything that's related to the invention that has been claimed in the application. And they'll issue a report identifying these documents, maybe with an initial opinion on whether it's patentable, is it new, is it inventive over what they've found. That initial search, depending on where you are, will normally come through within a period of a few months. And then you enter a substantive examination, and this is where there might be more of a discussion between the applicant and the examiner about whether the invention should be granted a patent. It might involve making some amendments to what we've claimed, and we'll talk a bit about that later. But that whole search, examination, application process takes a period of a few years. But after 18 months from filing, the latest, the application is published. So this is often well before the patent is granted. And so we see two types of publication, an application and a granted patent. And we'll come on to the reasons why that's important, but I just wanted to explain first why I'm referring to a patent document generally, and that might encompass patent applications, but it might also encompass a granted patent.
A quick question sort of in between there. So 18 months is the mandatory publication, but sort of sometimes when you search, you see patent applications that are younger than that.
Yeah.
So would you mind sort of illuminating why that is and why someone might want to have their patent published earlier?
Absolutely. So it depends on timing, really. If you really want to get a patent granted as soon as possible to get protection for the innovation, you might want to accelerate that publication. One of the things that you have to do as part of the application process is publish your application so that everyone can see it, and that gives everyone an opportunity to comment. So the patent examiner is obviously doing his examination, but potentially there might be other competitors in the market who see this application and want to challenge it, want to attack potentially the validity or introduce new documents that show that it's not novel or not inventive or something like that. So there has to be this period of time for which the application is published before it can be granted. So if we wait 18 months, which is the default, you're right, that's the default amount of time, the sort of maximum period of time after which a patent application is published. But if you want to get it granted as soon as possible, you might want to bring that forward. So you can typically request early publication, and that allows this whole process to be brought forward, and then potentially the entire grant process can be brought forward. So if you want a granted patent because you're aware of a competitor that's infringing, you can't actually do anything. You can't bring any action against that competitor until they have until you have a granted patent. So you might want to bring that whole process forward. Does that answer? Yeah, great. So the main sort of technical parts of the patent application is in the claims and the descriptions and drawings, and this is really what we would call the patent specification. This is what kind of sets out what the invention is and how it works. So we have a set of claims, and they're the bits that legally define the scope of protection. And we also have a description, and it's normally accompanied by some drawings, and these describe the invention in a bit more detail. And I'm going to go into more detail on both of those bits later. But that's the technical part. But there's also some important information that's sort of in the background of the patent document, and it can be important depending on our interest in the patent document. It can be important to understand this. Bibliographic details, I'll come on to those in a little bit more detail, but it's things like who actually owns the patent, what is it, where is it, all those sorts of things. But there's also an area which is worth knowing about, and I'm not going to discuss in too much detail, but the prosecution history. This publication process that we've been talking about is not only the patent specification itself, but also all the correspondence between the applicant and the patent office is open to public inspection. It's something that we can all see. And that can be a useful tool to have, the resource to be able to look at. If we are perhaps concerned about a patent, we can look at the history, what's gone on, what's been discussed. We can maybe get an idea of how strong the patent is, if there's any particular issues that have been raised. I say this just to make you aware that it exists rather than to go into detail about how we could use it. It's something that you likely want to work with the patent attorney on if, for example, you find a patent that could be problematic, or if you're a bit worried about, that might be a place to look. But it's just worth knowing that that information exists and it is in the public domain. So I'm going to talk a bit about bibliographic information, and I apologise because it sounds not very interesting, but actually, depending on our reason that we're looking at a patent or reading a patent document, this can give us some useful information. The first obvious potentially point is who actually owns it. If you're concerned about infringement, or if you're concerned on a commercial, or if you have commercial interest, knowing who owns the patent is an important thing to bear in mind. As I mentioned before, we need to consider, is it a patent application or is it a granted patent? So this is important because a patent can't be granted until it's published. It can't be enforced until it's granted. It can't be granted until it's published. But also it's important because during the application process, the scope of protection might change. So we'll typically start out with we're trying for quite a broad scope of protection, but actually the examiner might find something that's relevant. We have to amend the claims, and that will narrow down the scope of protection. And what this means is that the claim we read in a patent application might not be the actual claim that's granted in the end. And from a freedom to operate point of view, we need to know, is this an application we're looking at, or is it a patent? We also want to know what territory it covers. That could be a key concern with clearance or freedom to operate, is does it actually cover a country that I am worried about or that I want to work in? And then are there any other documents in what we call the patent family? So let's say it's not in a country that you're worried about. We need to have a look at whether there are any equivalents in countries that are more important to us. So just to explain what patent families are briefly, they're a collection of patents or patent applications that will generally cover the same or similar technical content. So they're generally linked by what we call priority. So there might be a first application in one place, and you can then file further applications in other countries to the same invention. And we use this system called priority to backdate our filing. Essentially, it means that if you file for protection in one country first, you have another period of 12 months to then pursue protection in other countries. So it gives you a bit of time to do a preliminary examination in one country. You can identify where there might be issues before you decide whether you're going to proceed in other countries. The point being that we might have a patent family that has patents covering equivalent patents or equivalent applications covering different territories. We might also have multiple patents or patent applications that cover the same territory. So, for example, we might have developed a new method of doing something, and there are various steps actually. We might have a couple of steps in that method that show some sort of improvement. Now, we might want to protect each of those different improvements independently, but really they're wrapped up in the same process and invention. So we might start with one application that describes everything and claims one of those inventions, but you might also then do what we call filing divisional applications. So we separate out the separate inventions that are all within the same application, and we then might end up with separate or multiple patents or applications in the same country that cover slightly different aspects of the same technology. So it's worth being aware of patent families, because if we have one patent document on our desk or on our screen that we're looking at, we might want to have a look at what other patent applications or patents exist in that family, and where they protect the inventions and what inventions they protect between them. This information is generally something we can find on online databases, so it might not be something that we see in the patent document itself that we're looking at, but we can look on online databases. Google Patents is actually a very good engine for looking at what's around, and we'll look at an example later. And also there's a resource called ESPASnet, which is the European Patent Office's database of worldwide applications. So it's not just limited to European applications, but it will show documents from all over the world. Yes, I think we've got a question in the back.
Yeah, I use similar databases, but if you have any information on at EPO, a patent examiner, do they use the same database, or do they have different tools for searching prior art? Or just second question is that like, does the patent examiner's role is just to look for that prior art, and then like afterwards, like, does the patent examiner continue to be involved in the process? Like, how much is the role of a patent examiner at EPO during the application?
Yes, okay, good question. First, the answer to your first question is the examiners will have access to all sorts of databases and search tools that they use to come up with their search. I suppose the information that they have access to is not dissimilar to what you'd find on ESPASnet. ESPASnet will, I think, in theory, show most patent publications from anywhere in the world whenever they've been put together. So it's the same material that the examiner will be looking for. What they do have are different databases and search tools that they will be using to actually identify what's relevant, that might be a little bit more sophisticated and a little bit more detailed than the ones, the sort of basic searches that you'll find on ESPASnet or on Google Patents. So the information is perhaps the same, but the tools they've got are slightly different. To answer your second question, the patent examiner is very involved all the way through from this search through to grant of the patent. Ultimately, the patent examiner who's been assigned this application is the one you need to convince that the invention is novel and inventive. And so they will have heavy involvement. The search will be done, and then there's this process of potentially arguing. In an ideal world, they'll do the search and they'll come back and say, yes, your invention's new and inventive, you can have a patent once you've gone through the publication and all that. It's rare that that actually comes up, often because we'll start at something quite broad. We want to try to cover as much ground as we can. So normally there'll be some amendments on the part of the applicant, but that all goes to the patent examiner, who will then review any amendments, review any arguments you might put forward in favour of the inventive step, and they're the ones that you have to convince. And ultimately, they'll be that examiner will be the one who decides to grant the patent, will approve the text, the exact language we're using to claim the invention as well. And once the two parties are agreed, essentially the applicant and the examiner, that they're happy that this is what will be granted, that's when it goes through. So yeah, heavy involvement from the patent examiner all the way through that process. Just on the point of patent families, it can be quite a complex task to pick out exactly how lots of different applications relate to each other, where they come from. You can see some very big families with applications in lots of countries and multiple applications in the same country. And so if you are concerned about this, it's something that's worth discussing with a patent attorney who will be more familiar with picking that information apart and can hopefully talk you through it in a clear way. Some other information, bibliographic information that's useful are the dates, and these are things that we'll often see on the front page of a document. And I just wanted to mention this just to help you understand what different dates we're seeing. We see lots of different dates on a patent specification or on an application or on a granted patent, and understanding what they are can be useful because they're relevant for different things. So I've mentioned this priority date. What the priority date is the date that the first application for that invention was filed anywhere in the world. And the reason that this is important is it's the date on which the novelty or the inventive step of the invention is assessed. So even if there's a later application that's filed somewhere else, and it claims priority back to an original application in one country, it's essentially treated, for the purpose of examination, it's treated as if it was filed on the same day as the first one. So you might often see a priority date on an application, and that's where we're assessing the novelty and inventive step of the invention. Anything that comes after that point normally can't be introduced or can't be used to challenge the novelty or inventive step of the invention, because it's not part of the prior art at the time that application was originally filed. But then we also have the filing date, and so this just differs in that it's the date that specific application was actually filed. The reason that this is important is because it's the filing date that starts the 20-year term of protection. It might be, for example, that you are reading a patent document and it turns out to be more than 20 years old. The filing date was more than 20 years ago. So then you know, actually, from a freedom to operate perspective, that particular invention that's described might not be a concern because that 20-year period has elapsed. And then the publication date is another one to look out for. This is something that we'll see on patent applications, and it's the date on which the document itself was published, made available to the public. As we've discussed, for an application, that the maximum period after which an application will be published is 18 months from that earliest priority date. And it's worth, sorry, I just spotted a typo in my slide, but it's worth bearing this in mind because it's possible that there's provisional protection that arises as from the date of publication of a patent application. Ultimately, a patent can't be enforced until it's granted, but if someone sues someone else for infringing their patent, they can potentially backdate damages to the date of publication. So if someone starts infringing after this patent has been published, the application has been published, it's possible that any infringement up until and after the date of grant will be potentially liable for damages. So it's worth bearing that in mind, that actually the publication date can also be important for determining whether or not there's an infringement issue. There are criteria that need to be met for that to be the case for infringement of a published application to be found, but it's possible, so it's just worth bearing in mind.
Can you elaborate on this priority date? How does it relate to the other dates, or do you just set it, or what it's dependent on?
So it's the if the date that the application is assessed for novelty and inventive step. So what you do in the application process is you essentially put a flag in the ground with your first application, and that is saying this is the invention and this is the date that we're kind of claiming that we've made this invention. Essentially is when we file the patent application.
So it can be earlier than filing date?
Yes, so it can be, because what you have then, so we might say let's file the first application in Europe, and we have a period of 12 months after that to decide whether we want to file applications in other countries. So after 12 months, we might decide, okay, I also want to protect this invention in the USA or in Japan or in Australia or wherever else we might want to protect it. We can then file further applications in those countries and claim what we call the priority date, which is the date on which the first application was filed. What that means is that even though those later applications have been filed potentially up to a year later, they're treated as if they had been filed on the same day as the original application. And what that means is that if there's any prior art that maybe has been published in that intervening period, it won't be relevant to the patentability of the invention that's been claimed. That makes a bit more sense. It's
just to make sure that the priority date is the filing date of the priority application, so the very first application.
The filing date of the very first application, yes. And then it's possible to file further applications within 12 months of that period, of that date, and you claim what's called the priority date. So every application will carry a priority date, and that might be up to a year earlier than the date it was actually filed.
So, quick question, like from a researcher point of view.
Yeah.
So if I'm worried that something I'm working on is like patentable, like we decided to patent it, and like the moment we filled it, like after the priority date, the filling date, I could go like and publish my thing whenever I want, because then I could say like, oh, it's in the patent. Yeah.
Yes. Yeah. As long as you don't disclose anything else that goes beyond what you've put in your patent application. Yeah. So that gives you then the freedom to start disclosing your invention to the outside world. So yeah, in your scenario for an academic researcher, it's important to get that application filed before you start going to conferences to talk about it or publishing papers. You need to make sure that application's there to have your flag in the ground. From a business point of view, you might have a product you really want to get onto market. Again, in a similar way, before you get it onto market, put that flag in the ground. That sets your priority date. And then even if you've only started in one country, it still gives you 12 months before you need to worry about whether or not to file in other countries. But you can start talking about your invention. You can start disclosing it.
One question. With the priority filing, you also get some kind of number for how you can control if you are, for example, investor.
Some sort of, what did you say?
Like a filing number or something.
Oh yeah, so you'll have as soon as you file an application, you'll be given an application number. So yes, you can say then you've got something tangible. We've got a patent pending, something that's.
You can say patent pending when you have the number and this.
Yes, once it's been filed before grant, you can say it's patent pending. And so that's something you can use if you're talking to investors, for example, to say that you've done something to protect this technology, even if it's not yet got your granted patent. You can from that date give them an application number. You will probably choose, or depending on that process, you might choose to share the application and information about it. So if you've had a positive examination back, you might want to use that to say, well, I've not got an application granted yet, but actually it's looking positive. Here's some advice from my attorney, for example, that shows that explains, where we are with the application. So it's something in the ground to say that you've taken steps to protect the invention.
Yes, you mentioned 12 months. Is that the deadline to refer to priority propagation?
Yeah, so if you want to file any further applications anywhere, you have to do that within 12 months of filing your first. So let's start to look into specifications themselves and how we can read and understand them. As I said, the patent specification is really the technical bit. It's what describes the invention and sets out what we're claiming. So we have a few different parts of it. Every application will have a title, and that gives us an idea of what the invention relates to. Sometimes it's not actually very helpful. Before it's published, often the title is the only thing that the public can see. So if the public do identify that this, maybe they find patent application number, they can see the title. And so often we don't actually want to hold too much information in that. And so it might be something quite broad. But then there will also be an abstract. And as with any abstract, that's a short summary of the invention. It helps kind of give a brief, concise description of what the content of the document is. And it can help us identify as a first step whether or not this is something that's interesting. So as with any abstracts, that's something that can be useful for our own review. It's something that's also used in that search and examination process by examiners to try and sort of sift out important documents. We then have a description, which is a detailed explanation of the invention, how the invention works, what its advantages are. And then we have the claims, and these really are the heart of the patent document. The claims are the legal statements that define the invention and determine the scope of protection. So there's a lot of information in the description, particularly, a lot of information about what the invention is and how it might work. But really, when it comes to what the patent covers and what it protects, is the claims that are the most important. And it's important to know that, because if we're trying to work out what is protected, we can get distracted sometimes by what the description says, and it might have a load of information about variations and different possibilities, different ways of putting the invention into effect. But if we want to know actually what's protected, we need to focus on what the claims say. And then we'll have a set of drawings that illustrate different embodiments of the invention. So typically those drawings will be used in conjunction with the description to help explain the invention and help you read it and put into context what is being claimed in the claims. These sections might appear in different orders, depending on what the patent document is, whether it's published in the US or in Europe. We might see a slightly different format, for example, but really the same sections are always there. There might also be some blurring, not the claims, but there might be some sort of blurring of sections in the description, which I'll come on to, that can differ from country to country. But the same information really is always there. And as I've said, it's the claims. These are the heart of the document, and these are from a understanding the protection, these are the most important part. So I'll just talk through types of claims that we might see. And broadly, there are two types of claims that we'll see in a claim set. We've got independent claims and then dependent claims, which we'll come on to. The independent claims are the claims that define the invention in its broadest sense. So they'll include a set of features that describe the invention, but they're features, only the features that are essential to the invention. And they set out the minimum features that are necessary to work the invention. We might have additional features that could also be included. So they're not a limiting set of features in that sense. So this is probably best explained with an example. We can just consider a patent claim, an independent claim that's here. It says, we've got a device and it comprises 3 features, A, B, and C. So what that claim covers is anything that has at least features A, B, and C, but it also covers the same invention, but with additional features included as well. So you might have additional feature D or E or F. So you can add things to it, but what the claim sets out are the minimum features that define the invention. And this helps us understand whether or not this claim might be infringed if we're looking at an infringement situation. We might often have more than one independent claim in a claim set, so it's worth looking out for them. And the way you can spot them is that they don't refer to any other claims. So like this example here, we just have a device and it sets out the features. It doesn't refer to anything else. So this is really the invention in its broadest sense. We might have more than one, though, for a device. We might also have a system that the device operates within. We might also have a method that enacts what the device does. So we might have different claims covering slightly different things, but all that relate to the same invention. And you can spot those because they don't refer to any other claims. From an infringement point of view, these are the ones that are important, because if we infringe the independent claims, we'll infringe everything else. But then we have a set of dependent claims, a series of dependent claims, and these are narrower, more specific claims. You can spot them because they refer back to an earlier claim, and they define optional and they're normally preferred features that also may be provided in addition to the features of the earlier claim. So taking our example again, we had a first independent claim covering a device comprising features A, B, and C. So as I've said, this covers anything that has A, B, and C, and potentially anything else. As a dependent claim, we might also say a device is claimed in claim 1 and further comprising D. So we're essentially saying here that there's a further kind of aspect of the invention where we've got something that includes A, B, C, and D. The reason for these is they provide us options for future narrowing of claims if we need to. And I think this is probably best explained if we look at this diagrammatically. So that lighter blue circle might be our independent claim that we start off with. And we've defined the invention with as few features as we think are necessary to define the invention. And the fewer features we include, the broader the scope of protection. So that circle, that ground that we're covering is larger. Now, during the examination process, the examiner might find a piece of prior art, and there might be something within that prior art that overlaps with our independent claim. So prior art discloses something that is within that large scope that we've tried to claim in the first place. And that's where we find a lack of novelty. So if there's an overlap between what we've claimed and the prior art, our invention will be considered not to be new. And then there's also this sort of wider circle around the prior art, which is around our question of inventive step. So what is obvious from the prior art? And there we might also have a bit of overlap, potentially with our broad claim. If, let's say, it's new, it's something that's a bit different, but actually it would be obvious to do that based on what's in the prior art. And so that's where we'd find a lack of inventive step, that second area of overlap. So if we start out with a broad independent claim and we find some prior art that knocks us out in one of these two areas, we need fallback positions. And that's where the dependent claims come in. That's why we put them into the specification when we draft them, because we might have a dependent claim that actually doesn't overlap with the prior art in a sense of novelty or obviousness. And so we can then use that to amend during the application process and hopefully then get a patent granted for the features of that dependent claim. So you'll see them there in any granted patent or in any patent application, a set of dependent claims. And that's what they're for. That's why they're included. So how do we actually read claims? I think hopefully this example has shown that what we're trying to do is cover as much ground as possible. And so we choose claim language very carefully to try and avoid unnecessary limitations. If I accidentally say in my independent claim that it includes feature D, when actually feature D isn't important, or you don't need to use feature D, then our claim will be narrower than it needs to be. And that means there's opportunities for competitors to work around my patent. So we do use the language of the claim to try and make that circle, that original blue circle, the lighter blue circle that we looked at, as big as possible. And this can be one of the challenges in reading it, because we then, as a result, end up with some quite broad claim language. We might not actually use words to describe a feature that one might normally use. We'll use something a little bit broader, a little bit more generic. There are some common terms as a result of this that we find. These are just a couple of examples that I'm pointing out, because there's language that you'll see in very many patent claims, and sometimes we're not sure what that actually means, so it's worth just mentioning. The word comprising comes up a lot, and what that means is that it allows for other features to be included. As I've mentioned, you might have other features in addition to the ones you set out in your claim. And the word comprising means that your invention includes the features that you set out and might include others. You can compare it or contrast it, I suppose, to the words consisting of, which you might see in some patent claims, but that would be very limiting. So if I say I've got a device consisting of A, B, and C, that means it's all that device has is those three features. So if someone were to add any other features to it, they might be able to work around the patent. So normally you won't see that language, you'll see the language comprising, but that's why it's there. The word is a small word, but the word A is something that you see a lot, but that doesn't mean one. It doesn't mean you've only got one of something. So let's say you've got a feature, a component. There is one of them, but there might be more. Then we also see this word plurality, and that can be quite confusing. But that's used typically if we want to say there's more than one of something, but we don't want to specify how many. So we might say a table has a plurality of legs. That means it has to have more than one leg, but it could have as many as you want, really, at least three, I suppose. But then something that we also come across a lot is functional claim language, and this is where we're really using linguistics to try and stop ourselves from being too narrow. So a functional language will describe what a component does rather than necessarily what the specific examples of it are. And the way you might see this play out is some sort of generic term like a unit, a member, an element, a mechanism, or even a means for, coupled to some kind of function. So an example of this is a heating, let's say we've got a heating unit configured to heat a substrate. That's functional claim language. What we might actually have is a heater, some sort of resistive device in our apparatus or in a system that's creating heat. But essentially, it could be done by anything. You might stick it in an oven. You might have an element inside that's doing the heating. There's a lot of ways you could heat something. What's important is what it's doing rather than how it does it. So we use this functional language, such as a heating unit, instead of specifying that it's an oven, or instead of specifying that we've got a specific any specific means of heating. So we see a lot of this claim language, and that can be the stuff that's hard to decipher sometimes. And we need to use the description in the drawings to help us understand what that is. Now, this is an example that's hopefully not too hard to get our heads around. We know what a heating unit is likely to be and what it's doing, but actually we might find some language that's a little bit confusing. We can then refer back to the descriptions and drawings, see what examples it gives of that component, and we can understand then what it's trying to cover. Yeah.
So my question here is like, if the person who writes patent instead of heating unit, we would use the oven, and someone decides to use a kettle.
Yeah.
Does it mean that you're not infringing a patent anymore because you're using Apple now.
Yeah, it's a good question. In principle, yes. In principle, you can't guarantee you'll catch any infringement if it doesn't fall within the literal wording of the claim. So if we did say oven, that's what the claim is limited to. There is this idea of infringement by equivalence, and that's again another whole topic that's quite complicated and one that you need to talk to your attorney about. But it's possible in some countries that you might find if you do something that's not literally what's written down, but does the same thing in essentially the same way, you might be able to argue that it still infringes the patent. But there's certainly no guarantee. And when you're drafting a patent, you don't want to leave that to chance. You don't want to leave that to the courts to decide whether or not it's equivalent to what's in the claim. So that's why we get this very, very generic claim language, or as generic as possible, to try and make sure it falls within the scope of the claim, regardless of how, what specific configuration you use. So I suppose some tips on reading dependent claims. When we see a claim set, we'll go through some examples later, but it can be helpful just to first identify what are the independent claims, and these are the ones that really define what the scope of protection is, and then separate those from the dependent claims, which might set out some sort of fallback positions that the applicants put in place in case they need them. But then it's really helpful just to break down a claim into bite-sized features. We'll look at some claims later, and we'll see that actually it can be a lot of wording. They're single sentences, so there's no sort of full stops, there's no pauses, and so it can be quite difficult to kind of get your head around exactly what the claim is saying. So if you just break it down into features one by one, these are the features that the claim is setting out, and you can review each feature in turn and then consider what it's saying, what does it cover. From a freedom to operate point of view, you could then, if you're concerned that your product infringes this patent claim, you can then look through each of those features of the independent claims one by one and determine whether that feature is present in your product. And if all of those features are present, then there's a chance that there might be an infringement. You might be doing this the other way around, actually. You might have your own patent and you found a competitor product that you think infringes. And so you could do this exercise and look at each feature in turn and see whether that feature is present in the product, and that will help you determine whether or not it's infringed. So really, it's not complicated advice, but just breaking it down like that can help digest the information in the claim. And that, I hope, will sort of become clear when we look at some examples later. If there's a feature that's a little bit unclear, it's used some functional language or something that you're a little bit unsure about, you can use the description and drawings to help understand that. We're going to talk a little bit more about how we do that in a minute. But often this process will identify some ambiguous areas, some areas that actually we're still not quite sure what that means, what it covers or what it doesn't. And this is something that will then require claim interpretation. And so just really what we mean by claim interpretation is actually working out what the language of the claim does mean. And it's worth bearing in mind that this is really a lot of patent disputes, a lot of litigation hinges on this matter. We might have one feature and there'll be hours and hours of arguments about what that actually means, because that's what helps us determine whether or not something is infringed or not. So it's complex, it's constantly evolving. There's decisions, case law that comes out constantly that helps us understand how this is judged. But really the question that we're kind of asking ourselves, if a claim interpretation, is what would a person skilled in the art, so that's our skilled person that we talked about earlier, who knows about the field, what would they understand the claim to mean? But if you're going through this process and you identify ambiguous features, it can be helpful to feed that information back to your patent attorney when you're having these discussions, because it might be that you're in a better position to identify where there could be some ambiguity than your attorney. So helping to understand where there might be some confusion can help that conversation. So I'm just going to talk a little bit about the description, and again, we'll come on to some examples that I think will put this into play. But the purpose of the description is to then explain how this invention works. So this invention that's been set out in the claims, how can we actually use it? How can we do it? How can we make it happen? It's got to provide enough detail for this skilled person to be able to put the invention into effect, so to make the invention, to use the method if it's a method, without having to invent themselves. So this comes back to the matter we discussed earlier about a full disclosure, what the invention is. That's the trade-off. And the description has to put enough information out there to enable someone to actually use it. And that means there can be some useful information to glean from the description about how it's being done. It will always include a description of at least one specific embodiment or an example of the invention, and we refer to those as embodiments of the invention. And the description will often discuss what the advantages are, the benefits, and the technical effects that are provided by the various features of the invention. So really, they're putting the claims into context. And as I said earlier, the specification is telling this story. What is new? Why is it clever? The description is helping us to flesh that out in more detail. And it's divided generally up into a few different sections. So we'll have a background section that discusses the relevant state of the art. So what's the prior art that exists in this area? And it indicates what problems this invention is trying to address. We'll then have a summary or a statement of invention that again describes the invention in quite broad terms. And you'll often find that follows the language of the claims. So one of the challenges is that the description will appear first in the document you're reading. The description will often appear first. And if you just start straight out going through the background and into this summary of invention, we find that actually we've got some confusing claim language, confusing language describing what the invention is. And it can be hard to get our heads around what it actually is. So understanding what that section is there for can help us do that. And we might then want to refer to other parts of the description to make a bit more sense of the document. And then we have a detailed description, and that describes a specific embodiment or several embodiments of what the invention is, how it's done, how it's put into effect, and often with reference to drawings. And this is the bit where it can be really useful information on what research has actually been done, what examples has the applicant actually come up with of this invention. And from understanding the technology, this can be really useful, and understanding where there's useful technical information in there, this is where we want to look. And it can also be useful for assessing the patentability of your own invention. The claims themselves, because they're quite broad and they don't give much detail, often don't help us much. But we've got specific examples in the description, and you can see what's different about your invention over what's in the description of this document, identify what the differences are, and are there any benefits or advantages to what you've done? And this helps us make an assessment on whether your invention might be patentable. So in the detailed description, actually, we find a lot of technical information that can be very useful. So just to sort of headline, the claims define what the scope of protection is, and the description gives detailed explanation of the invention with examples. Patent will normally cover something that's much broader than what's described. So the patent claims define what that scope of protection is. If we read a description, it's not just that invention that's covered. Actually, it's probably covering something that's a lot broader. And so we need to understand the difference between those sections. So how you read the document will probably depend on why you're reading the document. And if your main concern is something like freedom to operate, or if you're assessing potential infringement by a competitor of your own patent, really the claims are the place you want to go, because that's what sets out the legal description, the legal protection. But from an intelligence point of view, if we want to see what research has been done, it's actually the description that contains a lot more useful information. And as I've said, in reality, you're probably going to need a little bit of both. These go hand in hand. To understand the claims, we might need to look back at the description. And also, if we're looking at the description to understand what the invention is, we need to look at the claims. But understanding how they interact and what they're there for, I think, can be helpful for reading.